This is Martin Barrios, editor of Spero News. We're talking today to Katie Duke. She's a summer clerk with the Pacific Legal Foundation and a law student at the University of Miami. And we want to ask her today about a case that some have been calling Docs versus Glocks. Ms. Duke, I understand that there have been some recent developments, but I wondered why is this a funny name, Docs versus Glocks? What is this about?
Okay, first of all, thank you for having me. This case is actually called Wolschlager v. Governor of Florida, and it is about, back in 2011, they passed a Florida law, and it's basically a gag order on doctors, and it says doctors aren't allowed to ask their patients about gun ownership during routine medical examinations. And this case is just really important because it has to do with the First Amendment and how the state can regulate professional speech.
But, Glocks, I would assume, is a reference to firearms. Is this a case where Second Amendment and First Amendment rights are opposed, or can you give a little more background on that?
Sure. The law is called the Medical Privacy Concerning Firearms Act, and it basically says that physicians aren't allowed to ask their patients about gun ownership unless it's deemed relevant to the patient's medical care or safety. So PLF actually wrote a brief in support of the doctors in this case by Caleb Trotter and Deborah LaFetra, and our argument is basically, that this case is about the First Amendment, not the Second Amendment or privacy rights. And if doctors don't have freedom of speech, then no one really does. And who's to say where the stopping point is on this issue?
But I understand that the law was passed out of a concern by some people that they were being harassed by doctors about the firearms that they own, and there were concerns that the fact that these people do own firearms could then be an infringement upon their Second Amendment rights.
I think that reports of that were very few, and this law was heavily lobbied for by the NRA. And really, this law is just about the First Amendment, and doctors are really allowed to ask whatever they want in routine medical examinations. And just for an example, pediatricians often ask their patients about things like what sort of fencing you have around your pool at home, or what types of cleaning products you have in the house that could be a potential danger to children. It's really up to the discretion of the physicians, and if their First Amendment right is so restrained, physicians will kind of be afraid to ask those sorts of questions, and if they do ask questions that the state deems are irrelevant to the patient's safety, they can face fines and suspension or even have their license revoked.
How could they have their license revoked if they are not if they don't ask questions about firearms?
How can they have their license revoked?
I guess that's what I understood, is that if they don't ask all of the questions that they think are relevant, that somehow their professionalism would be in jeopardy. That's
a good point. I think that really the physicians and all of the different medical rights groups involved, their main concern is really just the impact of this regulation overall and how it'll be a slippery slope, and they're just afraid that if you cut into the free speech of physicians, how this can affect their profession as a whole. And really all Americans should be worried about this because it can affect other professions like lawyers or teachers or journalists.
I know that some defenders of Second Amendment rights are concerned that should, for example, in the future a law would be passed that would call upon physicians or maybe or psychiatrists, people in the mental health business, if they sense some kind of violent ideation, and they know that the patient is a gun owner, that then they would in turn denounce them to law enforcement authorities. What's your response to that?
Well, I think in general, you just want physicians to feel comfortable when they're talking to a patient, and especially in light of everything going on out in the world today, you just want them to have the discretion to ask their patients about whatever they think is relevant without worrying that the state will step in and say that really isn't relevant to the patient's treatment. And this case is just really about First Amendment rights for all people, and it's funny that they think asking a question about guns violates the Second Amendment, but banning speech doesn't violate the First Amendment. But if
let's say there is the fact that the person owns firearms, for example, is then recorded, would not then, if this must be reported to the authorities, would this not be a potential jeopardy to the Second Amendment?
I'm sorry, I don't quite understand your question.
I guess it's a hypothetical. I mean, if there were to be a law passed that requires physicians and psychiatrists, psychological professionals, to report to law enforcement that a person who is a gun owner, or maybe even a person who is not a gun owner, has violent thoughts,
right,
and then is compelled to report to the authorities, oh, this person expressed violent ideation, expressed violent thoughts about the federal government, for example, and then therefore that person could be put on a terrorist list or a no-fly
right.
list or a list prohibiting that person from purchasing firearms. Would not this prohibition, as you call it, on asking patients about firearms be to the benefit of preserving Second Amendment rights?
I just think it's a real slippery slope, and that all individual rights under the Constitution should be withheld. And if a law like that were to be passed, it would be a whole different issue and under privacy rights, and that this is just really about preserving the First Amendment. And the Supreme Court in general has upheld strict scrutiny and really is reluctant to allow just general restrictions on content-based speech. So in general, it's just about preserving the First Amendment, and if that issue were to come up, it would be, I think, in a whole different realm of individual rights.
Now, I understand that there were some developments at the federal court in Atlanta yesterday. Do you know what transpired?
Well, yesterday they heard the case for the fourth time, and the opinion should be coming out in the next few months, and hopefully they get it right this time. The past 3 times, a panel of the 3 of the same judges have heard the case, and then yesterday it was really rare. They heard it on en banc review, which means that all of the active judges of the 11th Circuit Court heard the case and are deciding it for the 4th time yesterday.
Excuse me. What has been the argument on the part of the Florida Attorney General, Ms. Bondi?
I'm not exactly sure of her exact stance, but the first time that the law was upheld, they said it was just a regulation of professional conduct, and then once there was a lot of backlash, the second and third time they had to admit, this is a restraint on free speech, but it's allowed because it's controlling professional speech.
Now, and I know Pacific Legal Foundation does some great work in the areas of property rights. So what was it about the case that interested the Pacific Legal Foundation?
This case is really relevant when you look at economic liberty and freedom of speech in PLF is really just about preserving individual rights and values under the Constitution.
So, but now is the Pacific Legal Foundation? Is it not a party to the suit, but of counsel to any of the parties?
The Pacific Legal Foundation wrote a friend of the court brief at the beginning of this year by two of its attorneys, Caleb Trotter and Deborah LaFetra, and it was really just in support of the doctor's stance, and PLF advocated for the principle that all content-based speech restrictions should be reviewed under a very high level of scrutiny so that free speech isn't threatened, because once you're allowed to control the speech of physicians, it's just whose else speech are you allowed to control?
What were some of? Do you happen to know what were some of the specific instances where the doctors who are party to the suit felt that their First Amendment rights were infringed?
I don't have any specific examples in front of me, but I know that a lot of them were pediatricians, and they just think that this will threaten their overall ability to have the discretion to talk freely with their patients. And a lot of the plaintiffs are in favor of the Second Amendment, too. I know Dr. Wolschlager himself has a concealed weapons permit.
Oh, that's interesting.
Mm-hmm.
That's interesting. So they don't see any conflict between the two, these two basic rights?
I think that they really are just about having free, open conversation, and a lot of them are for both the First and Second Amendment, and they just don't want the state to overstep its bounds in controlling their profession.
Isn't there a danger, though, if, for example, children are asked questions by a pediatrician when perhaps a parent is not present, and we know there are instances of professionals who have prompted children to give desired answers, that there could be, for example, children who are being compelled to inform on their parents, or out of a misunderstanding, for example, and thus infringe on the gun rights of their parents?
Right. Well, I think it's really up to the parent to be with the child during the medical examination, but if anything wrong were to happen, there would hopefully be other laws to come in, and if the physician is practicing medicine in a way he shouldn't be, there should be other laws and different protections to step in.
What were some of the arguments that the Pacific Legal Foundation attorneys used that you found notable?
Well, they just really advocated for the general principle that all content-based speech restrictions should be reviewed under strict scrutiny, which is the law's highest level of scrutiny possible for situations like this. And the Florida court, the federal court, upheld the law under the professional speech doctrine, but the Supreme Court has never really ruled on what level of scrutiny professional speech should be evaluated under. So this is a case that really could possibly go all the way up to the Supreme Court.
Do you think that the Florida AG may appeal and go to the Supreme Court on this one?
I think that whichever party doesn't get the outcome that it wants, there will likely be another appeal. Especially since, it is very rare that the same panel of judges would issue 3 decisions for the same case, and then on bank review is granted for the same case, making it a 4th time.
Now, would you hazard a prediction? Since it has gone en banc, what would be the outcome?
Well, hopefully the law will be struck down and be found to be unconstitutional.
Is there any way that it could be modified or curtailed, do you think?
That's a good question. I think that overall it just needs to be struck down because of all the different components of it that really just restrain physicians' First Amendment rights.
This was passed by the Florida legislature, am I right?
That's correct, in 2011.
Were they forewarned about passing a bill that could conflict with First Amendment rights? I'm certain. I would imagine they didn't pass a law frivolously.
Well, I know that the law was signed in 2011 by Rick Scott, and it was heavily lobbied for by NRA advocates. And other than that, I just know that after the act became law, 4 days later it was challenged by physicians and medical rights groups, so it really was a contentious topic.
Well, which are the, do you know which other organizations or individuals have filed friend of the court briefs on the side of the physicians?
I think that the American Bar Association filed a brief in support of the physicians after the first or second opinion. And
has ACLU come down on one side or the other in the case?
I'm not sure on those details.
Well, I appreciate you talking to us. This is it's a fascinating case since it obviously involves varied constitutional interests in the middle of a very contentious period. With there in Orlando, obviously there's been a lot of attention focused on possession of firearms and mental health too, in the case of the shooter there. So we really appreciate talking to you.
Yeah, thank you so much for having me, and hopefully we'll hear more about this case and the opinion coming out soon.
Thanks again. We've been talking to Katie Duke, a law student at the University of Miami, who is a clerk at the Pacific Legal Foundation. And again, I'm Martin Barrias, editor of Spero News. Thanks very much.